Okay, thank you for joining us. Welcome to today's webinar, and we hope to do a deep dive into California Senate Bill 553. Just a couple of housekeeping items. Please, we encourage questions, and you can submit those via the question feature on the webinar control panel. If we don't have time or we need to have a more detailed answer that can't be addressed in the team, we'll follow up after the webinar. And the presentation slides can be downloaded from the handout section of the webinar control panel. The webinar will be recorded and will be sent out for on-demand access after the session. And at the conclusion of the webinar, we would greatly appreciate a short survey will be launched, and we greatly appreciate your feedback on that. So thank you. We're getting started. So next slide, please. This is our standard Sikich disclaimer. For those of you that want to read it in more detail, that'll be part of the handout and the slides for that. So thank you. So just for those of you that aren't familiar with what Sikich does in this space, my name is Matt Doherty. I'm the Managing Director of Workforce Risk Management here at Sikich. I spent many years and retired from the Secret Service as the agent in charge of the National Threat Assessment Center. And for the last 15 years, have been developing workplace violence prevention programs, policies, training, record keeping, and actually and part of that is consult on serious cases of concern for not only public sector but private sector as well. So definitely something we have a lot of experience in regards to this new legislation. So this is what we hope to accomplish. What is 553? We hope to take some of the mystery out of it and explain in plain speak what it is, why it matters to you, and what your next steps should be. But before I get started, I'd like to give our first poll question out. How prepared are you for full compliance by July 1st? And we have had conversations with California OSHA, which we'll talk about, and they do mean to enforce this by July 1st. Well, that's good. It seems like you have a significant portion, the majority, are halfway there, and that's great to see and hear. Making a strong start. Well, at least people are aware of it, and we applaud those that haven't started to attend this webinar just to see what this is about, and we hope this will be useful for you as you strategize your way forward into being compliant with 553. It does take a lot of effort to be compliant. There are certain steps involved to comply, and the time is to get started now. So we're glad that almost half of you are halfway there, that the rest are either have started or are attending this webinar to learn more. So some of the basics. It's really important, and we've had extensive conversations with California OSHA and a lot of experience with this space, as I said, in the last 15 years. And we couldn't agree more into their position that each company plan has to be tailored specific to the location. For instance, if you have a company that has a corporate headquarters and perhaps a manufacturing division, those would require two separate plans because there's two separate sites with two completely different demographics with job hazards, et cetera. But if you have multiple office locations that are similar in scope and size, similar in construct, then perhaps one plan would be appropriate. But the bottom line is they have to be tailored to your organization. You just can't pick this off of the shelf and think that you're compliant with merely just a checklist. So it's important really to find out how did we get here? Well, it was legislation from the California Senate. And what happened was in May, for those of you that don't know, in May of 2021, a transit authority located in San Jose, an employee there killed 9 before committing suicide. And not surprising to us, as we were coincidentally interviewed in the media in San Jose, myself and our CEO, Chris Geyer, were interviewed pretty extensively in the San Jose media because we were known in the space. The person had all kinds of warning signs. He had anger management issues. He talked about killing people. He was well known by coworkers of being concerned. He had a pattern of insubordination. He was known by law enforcement. So really, a credit to State Senator Dave Cortez. He really made it his mission, his public service mission. Let's get some laws on the books, and it's the first laws that we know of. There are OSHA compliances and best practices and standards throughout the country, but this is the first legislation where it really has some teeth to it for enforcement, and that enforcement starts in July. Now, interestingly enough, California OSHA has stated to us there isn't a standard yet. That is evolving. We expect that standard to come out in the next year or so, but that doesn't negate your obligation to be compliant by July 1st. And they have said that penalties and fines will soon to follow for those that aren't in compliant and do get cited. Now, there are exceptions. It does apply to California employers with 10 or more employees on site, but there are exceptions to this. Healthcare, for instance, and corrections and law enforcement. Those two have their own OSHA requirements that have been in existence for many, many years for obvious reasons. Those are some of the most serious job hazard locations, healthcare and law enforcement and corrections. Teleworkers who volunteer or are working from a location outside control of the employer, you're not responsible for them. Even if they've had that option, if they are working from the home, for instance, you're not responsible for them. And we can't think of too many examples, but locations not open to the public with less than 10 workers at a time. So basically, 10 or more employees covers most public sector and private sector entities or institutions that work in California. There are many examples when we're interviewed in the media or actually working cases where California OSHA has already fined and penalties under their pre-existing OSHA guidelines. For instance, 2 employees in Half Moon Bay, following an investigation into workplace violence that killed 7 agricultural workers in January of 2023, were cited. California Terra Garden was the company, and they were cited for 22 violations, including 5 classified as serious and 1 classified as serious accident related. The total proposed penalties were $113,800. Concord Farms was also cited in this case for 19 violations, and the proposed penalties were $51,000. What I want to emphasize, this does not include the civil lawsuits that surely follow. Most of our clients, I can only think of one that there was not a lawsuit that followed a major workplace violence incident with serious injuries or fatalities. So that doesn't include the millions that can cover those types of issues. So there are direct and indirect costs. And for those of you, when I said we work active cases, the financial impact of workplace violence, it's a $130 billion financial impact of workplace violence annually in the U.S. And there's a lot of research out there, whether it be the Association of Threat Assessment Professionals, the FBI Behavioral Analysis Unit, and other research entities. There are significant financial impacts on companies and organizations when violence enters the workplace. We had a case relatively recently where we were called to provide a safe termination for a person that was having anger management issues. They were never our client. It was obvious they didn't have a plan in place or training in place to recognize warning signs, but they went right to a zero tolerance policy for some anger management for a pretty well serving longtime employee. We made arrangements for him to have a severance package. We secured the area, and I made arrangements for surveillance to follow him off the grounds. It was that serious where we wanted to make sure that he did not go back to his workplace. We followed him all right, and we followed him right to the gun store. And if you think about this, a termination is not illegal. Anger management unless you assault somebody or threaten somebody, is not illegal. To walk into a gun store with your own license is not illegal. But to do this within a 90-minute period of being fired, no one was hurt. Uh, our psychologists on staff and I liaisoned with law enforcement and with his spouse. Um, she was quite upset, understandably. She didn't know he was off of his mental health treatment prescriptions, and nobody was hurt. But the CEO and I had a discussion a couple days later. It made national attention. Um, Coworkers were very upset. They had to close factories. So, and we had to provide protection for a list of people he didn't like. It cost him upfront about $500,000. There were no lawsuits because no one was hurt, fortunately. But the loss of productivity, not to mention the negative publicity, his number one concern, after being grateful that nobody got hurt, was the reputational damage and the poor morale. Frankly, people didn't want to go back to work. It gravely impacted the operations of the company and caused a lot of fear in the workplace. So it definitely has some low instance, but very high impact events. But these are how these, with each and every case that we've come into with our clients for the last several years, it definitely has proven to be improved retention and morale, enhances that strong business continuity, and really does, it's been pretty well proven, it does reduce that risk of lawsuits. So for a minimal investment, it really does ensure that courtesy, respect, and safety, and really making sure that you have a more secure workplace. So again, we applaud the legislation here that took place. So here's our other poll question. What aspect of 553 compliance do you want to hear about the most? The written plan, the training, the record keeping, reporting, or all of it? Here we go. The vast majority is staying strong. You want to hear about all of it? That's very pleasing. I'm kind of not surprised about the training and the others, that some of you want to hear more about that. There's just different facets to this. So thank you for this, because that's what we're hoping to accomplish, is giving you that broad um, aspects of all these components that are a requirement of the legislation. So first of all, for those of you that perhaps are members of the Association of Threat Assessment Professionals, this is not new to you. I'm fairly confident that if there was a fight in your workplace, or someone directly tried to assault somebody or threatened with assault, or had an overt sexual harassment, that gets reported. That follows into your zero tolerance. But if you notice the definition of threat, because most people don't threaten their targets prior to an attack. There are courses, graduate courses in threat assessment, which I've taught for many, many years. But for California, they broaden that definition, which is a good thing. And if you notice in there, it covers a lot of areas for injury, trauma, stress, and also includes animal attacks. That's an interesting facet of it, but can you imagine delivery personnel, et cetera, being subjected to possible animal attacks? But as it's defined, and if you notice in here, this gives you a further definition of how threats can be either perceived or conveyed. And the one thing that is to be emphasized, so many of these cases, including the San Jose shooting, the coworkers reasonably perceived that there was a danger in the workplace. They had nobody to report it to. When they did report it, it went unanswered. There were concerns. But any of those behaviors that instill fear in the workplace and broaden this definition of violence, not just a direct threat or assault. So we applaud this definition, and we adhere to these principles ourselves. And it's not a new invention by California. OSHA, the Association of Threat Assessment Professionals, and many other organizations have endorsed this philosophy about threats, that it's not just a direct threat. So the law requires that you categorize and document different types of cases. This isn't just that worker on worker, although this is one of them. It's criminal intent. Somebody who has no legitimate business at the work site, including violent acts by anyone who entered the workplace. It could be a customer, client, visitor, vendor, um, if it's directed at employees. Worker on worker against an employee by present or former employee, supervisor, or manager. Uh, and that's why it's so important to do training on warning signs and personal relationships uh, by committed by somebody that doesn't work there but is known or known to have had a personal relationship with an employee. That is critically important, especially when it comes to domestic violence. Domestic violence is of epidemic proportions. In prior to the pandemic, 30% of women killed in the workplace are killed by an intimate partner. Now it's 40%. And I'm not to imply that males are exempt or not immune from being a victim of domestic abuse, but the statistics for women is really off the charts. And that's just one of the reasons why it's so important that you need to have a physical technical security assessment, not only physical security, but policies in place and training in place to have this all encompassing relationship. So, again, there's 4 types of people that could be categorized in your record keeping. So, you are required to have a written plan. Uh, Many employees post their required safety plans on a company intranet or in binders on the work site or posting them on bulletin boards in common areas. It's a lot like an evacuation plan or emergency management plan to make sure they have access. It does identify those responsible and their responsibilities to be the manager of this. You have to name the person with their title. And it's very important. There's attrition, of course, in the workplace. It's very important to keep that updated. You could be cited for not having updated. That person could leave your company and you haven't replaced them or replaced the title. There's different hazards at different locations. The workplace violence plan would need to be customized for each location. If the company has consistent and similar hazards and risk all across its work sites, then the plan can be more uniform across a larger footprint. Let me give you an example of some of the hazards. For instance, if you're in a retail establishment and somebody's a worker and they go out to the back alley to empty the trash and the back alley's not lit, uh, that's a job hazard that has to be considered and corrected. The implementation really needs to be coordinated with other subcontractors. Today's U.S. workforce is full of subcontractors, all working perhaps on the same project or the same mission space. But as you're implementing this plan, it should be done in close coordination with the subcontractors' employees that are working in close proximity. And that falls into those types that we talked about, contractors, visitors, that type 2 that we're talking about. And you are required to review and update the plan on a regular basis. So you really need, it's a requirement to have active employee involvement, and that can be monthly safety meetings, department meetings. It could be anonymous surveys, and we found those are very useful. Some people aren't comfortable reporting concerning situations, so anonymous surveys are very useful for us with our clients. As far as communicating, that includes broadcast SMS, the same type of broadcast message you might use for a natural disaster, like a hurricane or a tornado or, a crime in the area, a public address system, as long as it's done in good faith. And you need to ensure that the employees know they're protected from retaliation for reporting. We've had a lot of instances where if somebody reports a concerning situation, they're shunned upon or denied promotion, many times illegally. So you have to consider that. And as far as developing provisions to encourage employees or implementing disciplinary measures, uh, the last 2 are delicate as the threats and incidents are often sensitive and confidential. So while you most likely can't share exact details, such as somebody being a victim of domestic abuse, extremely private information of most situations, you can reiterate key points from the importance of reporting. And you need to instill trust. That's the key. And for my HR colleagues out there, I know they would fully endorse that. To be able to trust HR management and support mechanisms within the organization is just critically important. So it's really about prevention. It's a preventive approach. Part of the management plan means it could not that it could happen, uh, um, not if it could happen, but it could happen. And there's a preventive aspect approach to this, identifying situations that have the potential to lead. Nobody can predict violence, but if you can identify those situations, you need to identify perhaps somebody's a victim of domestic abuse or somebody's exhibiting untreated mental health or those job hazard examples that I talked about. It's really key to mitigate those hazards before they potentially could escalate. We're not saying every concerning situation would accelerate to workplace violence, but you really have to have that preventive approach in place. So next slide. So the workplace violence hazard and identification, really it's key to that. And it leads into sorry about that. Um, the workplace violence identification and mitigation, you really do have to have that mechanism in place where it's documented and those hazards are identified and notify them of hazards. Keeping them informed is critically important. Not only important, but it's a compliance for 553. So the reporting process, this is pretty nuanced. You need to have that reporting process for anything of hazards, concerning behavior, threats, or incidents, physical concerns, such as the lighting example I gave you. Um, and by the way, this doesn't preclude employees from reporting directly to local law enforcement, or they can call California OSHA if they fear retaliation. And anonymous reporting is really a best practice. We recommend it. It's not required in 553, but for you to get active reporting or accurate reporting, some people might not be comfortable reporting their boss for perhaps exhibiting anger displays or untreated mental health, or a high valued customer coming in, and you're not comfortable reporting a customer with concerning, perhaps threatening behavior. That's why we always want to leverage pre-existing anonymous hotlines or establish one for the reporting process. We've been doing this for many years, but we recommend that as part of 553 if you haven't considered it already. So there are training requirements that you can read here. You have to have knowledge of how to access the most up-to-date version of this plan, the employees do, and articulate and implement how employees can participate in the development of the plan. And what are the key definitions, as I said? Um, how to report workplace violence, incidents or concerns to the employer or law enforcement without fear of reprisal. Um, Workplace violence hazards specific to the employee's role and the corrective measures the employer has implemented, and how to seek assistance to prevent or respond to violence. Uh, there are strategies you can undertake to avoid physical harm. For instance, some of the training might be in one of our popular trainings that have been requested coming out of the pandemic in particular has been conflict resolution or de-escalation. We've had to have trained private security guard services has been very popular with that. Um, and we need an opportunity for interactive question and answer sessions with the knowledgeable party. So again, this is a group effort. When you're undertaking this plan, again, I know you're undertaking this plan with a select few, but at some point this has to be shared with the employees, and it's good to have those stakeholders involved in the creation of the plan so that there is a consensus and there is buy-in from the top down. Um, And in emergency response procedures, the plan you have to show detail. It cannot be just a mere cut and paste, off of the internet on a best practice. It has to detail effective means to alert employees of the presence, location, and nature of workplace violence emergencies. For example, alarm systems, as I said, and public uh, public um, announcing systems used to alert employees or emergencies. The alarms could be audible alarms, visual alarms, or both. And you can see this isn't just a policy, it's a tactical implementation to broadcast text messages sent to all employees. The employer uh, will have an evacuation or sheltering plans. For examples, the plan could include maps of evacuation routes, locations of emergency exits, instructions for sheltering in place. So a lot of you have a lot of the elements of this. Just utilize them and leverage them, refine them, and focus them as part of this plan. And also, how to obtain help should be provided from the staff for the staff, security personnel, or law enforcement, including contact information for response staff and local law enforcement, and post in common areas. Not just 911. Um, those of you should definitely have a familiarization with local law enforcement. And if you have a concerning termination, things like that, where you might want law enforcement on standby, regular meetings with law enforcement, so that the first you never ever hear from him is 911. 911 is great for imminent danger. Nobody should be telling their employees to call anyone else but 911 in an emergency situation. That should be their, we should never negate or deny them that first option of 911 in an imminent situation. So there are record keeping guidelines. They must be provided to California Ocean employees within 15 days of a request. And like I said, they have to identify the individual identifying information must be removed. We specifically called California OSHA about this, and they clearly have that understanding as well to strip that identifying information, PII information, names, dates of birth, things like that, must be removed. And specific details are required for each type of log. And just look at this, the hazard identification and mitigation measures. What was the hazard and what did you do to mitigate? That's kept for 5 years. The violent incident log and corrective actions is kept for 5 years. Incident investigations, 5 years, and training records. Now, some of you are familiar with the injury and illness and prevention statistics that have to be supplied to California. There's been some suggestion that you could make part of this record keeping as part of that. And without getting in the weeds too much in this 1 hour, this should be dealt with in most cases separately, to have these types of logs ready to go upon request and have them stood up with different record keeping. But you can see the retention that you need to have. And if you look at the training record, it has to be kept for a year. So that means new employees coming on, you have attrition, training should be conducted annually, and then you close the books on those, and then you do the training again every year. So again, in a post-incident response and investigation for this record keeping, you're required to investigate that in the violent incident log. But that violent incident log, a site visit, review of the footage, interviewees with involved parties, taking corrective action, and documenting everything in that violent incident log. It's just critically important. That's just some of the examples in the violent incident log that you have to have inputs to. So keep in mind best practices. These best practices, they're not part of the requirements, but are based on our years of personal experience and research and best practices. And again, those of us in the audience who have been doing this a while, I think would readily agree. It's all about fostering courtesy, respect, and safety in the workplace. Creating that culture, it fails. For instance, we've had clients where they're in fear of retaliation, or they don't want to get somebody in trouble for reporting. And if you try to get to that courtesy, respect, and safety, in other words, I'm not trying to get my coworker in trouble if I suspect they're a victim of domestic abuse. I'm actually trying to help them by reporting that suspicion. Untreated mental health, for instance. Those are the things. And how many times have you seen these incidents in the media where the coworker says, I knew it would be this person. We've always been concerned about them. We've always been trying to report him um, for that. So, you know, and show appreciation for when employees speak up. In other words, this isn't in 553, but it's what our experience has been to get that successful reporting for that, and and make sure you don't retaliate against somebody. Somebody could honestly say, "Hey, we're concerned about this employee," and after an inquiry, there might be nothing to it. But that doesn't mean the person calling it in, if it was done in good faith, should be retaliated against. So again, it's just critically important as you build this plan to be successful and to truly um, potentially save lives and injuries, to have that courtesy, respect, and safety and trusting environment for the reporting. So, and again, show that appreciation for employees speaking up. So there is, what should you do now? And again, we'll be supplying this presentation and of course open to questions and inquiries, of course, as we do for many of our clients that we've started this process in California. But review that legislation. We hope this presentation has translated some of it, but you really need a broader understanding of your requirements. Schedule team meetings now to disseminate the survey for employee input. To get that buy-in, is we recommended that before 553 for buy-in from the company when you're building a workplace violence program, but now it's a compliance issue. So you really do have to get that employee input, and we think the survey is the best route to go. Determine reporting mechanisms for employee. That could be phone calls, again, text, etc. Anonymous hotlines. Many of our clients, they have compliance hotlines like automobile manufacturers or factory lines to put that. You can leverage that compliance hotline to include 553 compliance and customize that plan. It's just critically important to customize that plan for specific information and adhere to record keeping guidelines. I don't see, do we have any questions so far? I might see one comment. And feel free to bring up these questions. We're definitely leaving some time here for a discussion for that. We've been doing this a long time, and up until now, it's been standards or guidelines or a nice to have with many of our clients. OSHA, the federal OSHA, has a duty of care. The Association of Threat Assessment Professionals, for those of you that are in the threat management field, I suggest you join. But they come out with guidelines and standards. We're members of Society of Human Resource Management, which is near and dear to the standards and guidelines that HR usually follows that organization. I'm right across the street here in Washington, D.C. from the SHRM headquarters, and they're putting out standards. But we've been following this for a long, long time and following these guidelines. But again, this is the very first time, and we're pretty enthusiastic about this, that 553 is the first strict compliance. There might be different nuances in other states, but already federal OSHA has come out with some statements, and everyone we've talked to is fairly confident this is going to reach across states. It's going to start becoming state law. It's going to be would not surprise me in just the next few years, as we have experienced all of these incidents of workplace violence where it could have been prevented, like in San Jose. Many people thought San Jose could have been prevented. We cited the warning signs and behaviors. Our CEO, Chris Geyer, talked about our training that's been in existence for many years that could have helped maybe prevent these types of things from happening. But we've been doing this for a long time. We've adapted the lessons learned. We've adapted guidelines. We're on the phone constantly with institutes like the Federal Bureau of Investigation Behavioral Analysis Unit. They come out with some outstanding reporting after an incident occurs that really articulate the preventive nature of many of these, the warning signs, the life stressors. All of this should be involved in the training sessions. Uh, we also supply record keeping models to be used on these 4 different record keepings and retention models for those. So, and Sikich, we've created a 22-page plan aligned with these California requirements. And we've really pretty proud of it. It's been adapted already. It's organized in a logical, understandable, and straightforward way. Uh, we can also include guidance for hazard mitigation measures, physical, technical, security assessments, and corrective actions based on this type of violence. And we can also provide an editable template for you to customize. And we'll evaluate your completed plan and provide recommendations as needed. Again, our basic conversations with California OSHA, when we describe what we do, it's pretty clear that we satisfy those compliance requirements. But we can help in a variety of ways at Sikich, and we can supply that support with all of that. So feel free to reach out to us on those types of issues.
Hey, Matt,
Yeah,
we've had a few questions come in.
great.
I, the first one is we have 3 employees in California. Our headquarters is in another state. We're a public shopping center with tenants. I assume we have to follow this being we're in a public setting, even though we have less than 10 employees.
Not necessarily. It really is 10 or more employees, uh, working within the confines of a office, a work site. However, if it was me and you have 3, what if you hire an additional one? And also, are you in a public setting with other places that have subcontractors? So, do they have 10 or more employees? And I would collectively gather all of your coworkers, whether they be employees or not, and get that plan written. Even if it's just 3, I would not rely on a technical compliance. I would rely on the fact on what environment they are in, what are the job hazards, and what if you hire a 4th person? Those are all factors that I would consider to implement a plan. I hope that helps.
Next question. What if we have no more than 10 people in the office at a time? Is that an exception? They have alternating schedules and more than 10 come in, but not more than 10 at a single point in time.
That's a compliance. If it doesn't matter shift work. If you have 10 people working in a particular location, it doesn't consider shift work. You have 10 or more employees working within a California company infrastructure, you have to be in compliance. So I get what you're saying. We only have 3 at a time. It's pretty rare that we have 10 or more in the office. That's clearly with California OSHA, you need to have a plan.
Next question here. If we have a team and office location in another state, do we need to count the people working outside of California?
No, you do not. However, as I said, we are fairly confident that other states will be following suit, as well as there's been some discussion that it will follow suit on a federal standard. So the answer is no if they're not working within California. However, we recommend, and it really potentially is a life-saving exercise. I would recommend being in compliancy. Um, and there's nothing wrong, which we do. As I said, we've been doing this for 15 years. I would recommend making sure that your out-of-state folks have a plan in place as well, because it's a nice construct to have a plan in place. That's what we've been doing for 15 years, and it's just amazing. We've had some pretty large companies, and we take a look as we're looking at their policies and programs. We'll get an employee handbook of companies that you know full well are nationally recognized, and there'll be a 1 sentence word in the handbook that workplace violence won't be tolerated. Well, that's not a prevention policy. So if I would recommend applying the California gold standard across the board to your other state offices.
We've got another question here. Can you explain who the training needs to be conducted for? Is that all employees, just managers? Can you elaborate on that?
Sure. It can be a variety of formats. What we found in our experience, and they're not too specific about it, but we found that the best way in workplace violence prevention policies and programs is not everybody needs the same type of training. We feel, whether it be virtual, in person, or on a learning management system that we have, um, every employee should be aware of the warning signs and red flag behaviors, what the policy is, what the plan is, who to report it to, really bring them in as part of the plan. Our philosophy is that policies are written by senior leadership of a company, decision makers. The program is the responsibility of everybody in the company. And I think the executives would agree with that. Your frontline employees are the ones that are going to observe the concerning behavior. They need to know who to report it to. As I said, different trainings are needed by different folks. For managers, de-escalation and conflict resolution, that's really critically important for your managers, and how to manage difficult situations. That's another set of training. So the general workforce training can be a short training. We know time is money. This is already, I'm sure, uh, the money and revenue people are looking at this closely, your budgetary constraints. That's a short training. Managers may be a little more detailed. There's also a best practice recognized by federal OSHA and others of having a threat management team. That means HR, security, legal, everybody has their day job. Some of our big clients have regional threat management teams. They deal with this every day. But a lot of these companies, smaller in size, of course, with this compliancy, perhaps train some senior leaders on how to deal with very concerning situations. It's called a threat management team. Some companies call it a care team. Some others call it a safe team, um, but a team of senior leaders. So again, three buckets of training, and they can be done in a variety of formats. Personal, in-person briefs, in-person training might not be practical. For instance, for a manufacturing floor, learning management systems are a very practical way. Just like you require many of your employees to take cybersecurity training, what is phishing, changing your password, have a quick primer on what the warning signs and a reminder are, make it part of your employee orientation. And then the manager's training, how to manage difficult situations, and de-escalation and conflict resolution are just key. We've had a lot of cases in this country where a disturbed employee, a concerning employee, and frankly, the cases were mismanaged and actually had an indirect result of escalating the situation rather than de-escalating. So we believe in those trainings as well, but different formats for different people. But one of the keys is that general workforce training, in-person, virtual, or learning management system according to the efficiency.
Thanks, Matt. And as a follow-up to that one, who should be conducting that training?
Um, and by the way, I want to remind you, 553 is for all employees, everyone from the owner, CEO on down to the line employee. It applies to everyone, just not your general workforce. I wanted to make that clear. And I'm sorry, could you repeat that question?
Yes, who should be conducting the training?
I think well briefed experts. Now you could take a train the trainer training, but who should train on it? Outside trainers such as ourselves, or you could do a train the trainer, but somebody with authority that really knows what they're talking about. For instance, the important thing is not whether someone made a direct threat, that shouldn't be tolerated, but whether a concerning person poses a threat. Some of those fundamental principles of threat assessment. Those that have experience in training and threat assessment, I think, would be a prerequisite.
All right, we have another one here. Are we required to train temporary employees who work on site but are represented by a third party?
Well, as I said, that should be done in close concert. The recommendation, the compliance issue, um, really you need to definitely coordinate with your subcontractors. And that's exactly what we're talking about. A temporary employee is essentially, in our opinion, a subcontractor. Um, and so, we really need, it can be an internal employee to provide the training, and we can provide the training materials for that. But it really, when you're talking about temporary employees, that's under that subcontractor um, compliance. So I would recommend getting to who runs that temp agency, if you will, and make sure they're brought in the loop on the plan for that.
So for the subcontractor topic, how do we best coordinate our plan with their plan? If they're fined by Cal OSHA, are we also party to that fine?
If they are fined, uh, that hasn't been real clear yet. As I said, the standards and guidelines are coming out in 2 years. However, I would definitely contact the leaders in that company, the appropriate person, whether it be director of HR, the director of security, that you're writing your plan, and it should be in close concert and coordination with the subcontractor's plan for that. And the penalties and fines, I think no pun intended, the jury's still out on that. But I think, as you saw in the example I gave on the Half Moon Bay, and we'll be supplying this deck for you, there were numerous companies fined. So I think California OSHA is going to look, was the subcontracting company, uh, responsible for their employee, and were they in compliance? Did they have a plan? Did they keep proper records? Did they get rid of those job hazards and mitigate those? And the same is going to apply to you that's asking that question. So there can be multiple penalties and fines for one incident with companies and subcontractors.
All right, I think we got one last question here, Matt. Would forming a representative employee task force for the development of the program meet the employee involvement requirements?
Can you repeat that question? I want to make sure I heard that correctly.
Yeah. Would forming a representative employee task force for the development of the program meet the employee involvement requirements?
That it sounds like a great approach. Just yesterday, we were on the phone with a client, and they had a peer group as we're on the second phase of implementing a plan. And this plan happened to be in another state, but they have a peer review group of employees, and we applauded that. So that sounds like a great approach to that, the use of the word task force. Sounds good to us.
Looks like we had one last question pop through quick here. Um, just want to verify that SB 553 does not affect healthcare locations such as community clinics.
That's correct. Now, don't ignore, if you haven't been following, we were told, not only in writing, but if you look at the legislation, it was explained to us that healthcare facilities such as those clinics, they are subjected to their own California OSHA requirements. So I would suggest be familiar with those, and hopefully you're in compliance with those under healthcare. Again, they're not exempt from a workplace violence prevention plan. It's coming out of the legislation and California OSHA that for several years, law enforcement, corrections, and healthcare have already been in compliance and subjected to fines and penalties according to their individual OSHA standards. I just want to make clear they're not exempt from an overall workplace violence prevention compliance. They're just exempt from 553 because they've already had their own compliances in place for several years now.
Thanks, Matt. That's all the questions we had for now, at least.
Well, great. And just, please call us anytime. Again, we have been doing this for a long time. For 15 years, we've been developing workplace violence prevention programs, policies, training. We provide case consultations, what we call behavioral threat assessments, what the industry and the Association of Threat Assessment Professionals. We look at intent, motivation, and capability, and not determining whether someone made a direct threat or not. So there's definitely some nuances to this. We We do applaud the state of California for implementing this. Again, they'll be the first to say we're still working out the details, but this is coming, and the fines and penalties will start in July 1st. They made that very clear to us. And as we close out, I hope you find this information useful. I know there's a lot of webinars out there and your time is valuable. We tried to make it as operationally relevant as possible and to expound to you that it's not just that we read this legislation and came up with a roadmap. We've been doing it a long, long time. But as a reminder, please complete the survey that pops up after this. We greatly appreciate any feedback on this and suggestions for future webinars. We welcome that. And we'll follow up with you with answers to any questions that perhaps you may have had, or that maybe some of my answers were not satisfactory. And as we mentioned in the beginning, today's session was recorded. We'll be sending it out for on-demand access in the next day or two. And again, if there's any other questions, please feel free. But other than that, a few minutes early, but I'm certainly glad we allowed enough time for some questions and discussions. But thank you for attending and have a great day.